My Lady, Mr. Dean and I appear for the appellant, the defendant in a libel action brought on a publication in October 2009. Mr. Nugent sits behind me. He's the gentleman in glasses. Ms. Mikolos appears for the respondent. The claimant in the action started in December 2013. He is the gentleman with a poppy in his buttonhole. And I start by seeing whether I can summarize the appeal issues in a nutshell. Ms. Mikolos invites the committee in her case to dismiss the appeal on the basis that the decision below was a legitimate exercise of the Deemster's discretion within that familiar territory where reasonable disagreement is possible. We respond that the committee can and should intervene on two well-established bases corresponding to the grounds of appeal for which permission has been given. They are, firstly, that the Deemster proceeded on the basis of a material error of law, which is now conceded, and secondly, that he made a finding of fact for which there was no basis in the evidence, indeed rather the contrary. The appeal raises a question in relation to the construction, or rather now in the light of the concession, the application of Section 30A of the Manx Limitation Act of 1984. That's in the bundles at Bundle 8, page 1583. I don't think I need ask you to go for it now, but the page reference may be helpful. The equivalent provision in this jurisdiction is Section 32A of the 1980 Limitation Act, the relevant parts of which are identical to the Manx legislation. And that's in Bundle 8 at page 1638. So let me turn first to the Deemster's construction of the legislation. As I say, that is now conceded to be erroneous.
So why do we need to bother about it?
Well, because one needs to see, my lady, precisely how the matter was subsequently dealt with by the Staff of Government Division. I'm not going to take long on this, I can assure you. I appreciate there's an open door, so I'm not going to try and kick it open. The issue, as your ladyship appreciates, is his error in looking at only 5.5 months of a period of 4 years of delay, the 5.5 months being thought by him to be the relevant period, namely that between the acquisition of knowledge and the issue of proceedings. So we say that insofar as the Deemster purported to exercise his discretion to extend time, that discretion was fatally tainted by his error in law and the consequence that I've just described, looking only at 6 months of a 4-year delay. The Deemster also, we say, erred in a second respect, notwithstanding what he himself called the paucity of the evidence. He reached the factual conclusion that the delay between the acquisition of knowledge and the institution of proceedings was prompt and not unreasonable, those being the adjectives in Section 30A 2B Roman 2. The decision of the Staff of Government Division is significant in one respect which strikes one immediately, namely that their honours say, it's paragraph 58 of their judgment, that they would each personally have refused to extend the time on the evidence that was before them. But they concluded that they could not overturn the exercise of the Deemster's discretion because it was in the range of what they called reasonably possible conclusions open to him. We say the Staff of Government Division approached this matter in a manner which was fatally flawed by their failure to see that the Deemster had erred in law, as indeed had they, and therefore the exercise of his discretion could not stand. So let me go straight away to the first ground of appeal. Conceded, and Lady Hale would be relieved to hear I'm not going to make any more of that.
I'm not sure I'm the only one.
No doubt. I imagine that's five love. Libel, as the committee knows, is special as a tort in that the limitation period in the Isle of Man since 1997 is only a year, and that's the same the same period as in this jurisdiction since 1996. Thus, time is of the essence, as it was put by Lord Justice Brooke, sitting with Lady Hale in a case that I'll come to later, Steedman and the BBC. The delay in the present case from the expiry of the limitation period on the 7th of October 2010 to the commencement of proceedings in December, on the 5th of December 2013, was over 3 years. And the delay was over 4 years if you measure the delay, as Lord Oliver tells us that you can, from the date of publication on the 7th of October 2009. The concession that is made is based on the decision in the House of Lords in Donovan and Gwentoys. That decision is in Bundle 6, 1310, page 1310. The relevant passage is at page 1316, between letters E and G, where Lord Griffiths applies what had been said by Lord Diplock in a case in 1981, Thompson and Brown. So I just draw attention to that being the critical passage, internal page 478 in the law report, in the bundles 1316. Lord Oliver, with whom the other members of the House agreed, certainly explicitly Lords Bridge, Templeman and Lowry, was of the view, and rightly we say of the view, that even delay prior to the expiry of the limitation period is relevant. One sees that if one looks at the last part of his speech, page 1318, between letters B and C. Can I now ask you to look at the Deemster's approach? I can do this quite quickly and then see how that approach was treated by the Staff of Government Division. Miss Mikolos says that the Deemster took into account all the delay. I'm afraid I can't accept that. Can we just go to paragraph 32, page 58 of the judgment of Deemster Corlett? It's true that he starts paragraph 32 by saying that the first aspect of delay is the overall delay. But he then, if one reads on, appears to discount it by saying that the relevant, and I emphasize relevant, his word, the relevant period of delay, in my judgment, is between that time and the date on which proceedings were issued.
Do you accept that different periods may be more or less relevant?
Yes, but I'd put it in that way, that there are passages in Miss Michaelis's case in which she tends to confuse relevance, which might be said to be a binary issue. It's either relevant or it's not, and weight. So the answer to your Lordship's question in a nutshell is yes, in that sense, that obviously different periods will be given different weight. The Deemster, proceeding on the basis of that erroneous view of the law, then at paragraph 47 said, the question, it seems to me, is whether the delay of 5 to 6 months in the claimant issuing proceedings, taken from the date of his awareness of the letter of the 7th of October 2009, has caused the relevant evidence to be unavailable. And to put it very shortly, he answered that question in the negative for the simple reason that the critical witness for Mr. Nugent, Mr. Goubet, didn't die until the 5th of January 2016. The way in which the Deemster's decision was treated by the Staff of Government Division can be seen if the committee goes to...
Just before you go on from that,
yes.
Going back to the question of the paragraph 32, where you were suggesting it was a binary decision whether something's relevant or not. In other words, not a value judgment, but something capable of a right or a wrong answer. And yet he says, in my judgment, this is the relevant period, which looks much more the language of value judgment.
Yes, I take that point. I respectfully adopt it, but it seems to flow from his erroneous view of the law. And we'll see that in just...
But he might just be saying, this is what's got the weight in this case.
It's not exactly what he's saying, and what he appears to be doing is treating this as the relevant period, and as your ladyship will remember, because I don't want to repeat the point more than once, the focus then becomes on only a small part of the delay, the 5.5 to 6 months, rather than the totality of the delay, which, if you take it from the time of publication up to the time of the issue of proceedings, is 4 years.
Relevant, of course, can be a somewhat elastic term. He doesn't say that the only relevant period of delay is between the date of discovery and the date of the issue of proceedings. And it seems possibly incongruous that he would have referred to the cause of action arising in October 2009 if he was leaving that out of account.
Well, true it is that the Deemster did not say that the only delay falling to be considered was that between discovery of the letter and the issue of proceedings. That's a point that was made by the Staff of Government Division. But my submission is that was the inevitable effect of what he said by treating it at para 32 as the relevant delay. In other words, the staff of government division were giving the Deemster the benefit of an undeserved doubt by relying on a distinction without a difference in the context of the case. You'll recall, if we move from the Deemster's decision to that of the staff of government, that they rejected at paragraph 33, page 81 of the bundle, the submission on behalf of Mr. Nugent that the Deemster had failed to consider all the delay from the expiry of the limitation period, and that thereby the exercise of his discretion was vitiated. My submission is that that was too generous to the Deemster. It wasn't right to say that the defendant's submission was based on a misunderstanding of what he'd said. By talking about relevant in the context in which he did, he was effectively implying that that was the only period. And even if it was right that it was significant what had or had not been done during that period, and I'll come on to that later, we say it was important to have regard to the totality of the delay, which makes this a very stale action indeed. The staff of government then introduced an error of their own at paragraph 61, when they expressed the view that what they called the plain and ordinary meaning of the statutory words was that the period since the expiry of the limitation period was relevant only to whether the cogency of the relevant evidence was diminished. In other words, the factor mentioned in 30A 2C Roman 2, and not to whether the evidence had become unavailable, the factor in 2C Roman 1. This might be thought, indeed I gleaned from Ms. Mikalos's case that this will be her submission, that this is a somewhat academic issue, but my submission, and I'll take this as quickly as I possibly can, is that there is no warrant for the construction adopted by the staff of government division, not least because delay in section 30A 2C must surely have the same meaning as in 30A 2A. Also, with due respect to the staff of government division, it makes little or no sense. Unavailability and diminished cogency are expressed as alternatives. And in the English cases, diminished cogency and unavailability are treated in the same manner. One can see that if one looks at a very recent decision of Sir Terence Etherton in a case called Carroll and Greater Manchester, which is in Bundle 6. The relevant paragraph is paragraph 8 at 1305. Actually, paragraph 8 is a subparagraph of paragraph 42. But if the committee goes to that, you'll see that there's nothing there to suggest that the Master of the Rolls regarded the two as needing to be treated differently. And we say, and you'll have seen why we say in our case, that if cogency and non-availability really were separate tests, it would produce absurd results. I give one illustration in paragraph 17.1 of our case, and it's this. if a witness is available, but the passage of time has robbed his memory of events, then prejudice by reason of the delay since expiry of the limitation period may be taken into account if the staff of government construction is correct. But if the witness dies, and obviously as a result it is not available at all, then only delay since the date of knowledge is relevant. The approach adopted by the staff of government division was one in which they speculated about the intention of Tinvald. One can see that in paragraph 61 of their judgment. It's page 87 in the bundle. They say that although Mr. Callin, who was the advocate for Mr. Nugent, submitted that this would, the construction that the staff of government were inclined to place on the section, produce an illogical result. In our judgment, that is the plain and ordinary meaning of the statutory words, and had Tinvald intended that the words above should apply to both section 30A2C1 and C2, Tinvald section 30A could have easily provided, and it did not do so. Well, of course, that was an invitation to us to look and see what Tinvald had in fact done, and we say there is nothing, we'll look at it in just a moment, there to justify the drawing of any distinction, let alone one which could be described, staff of government division described it as plain and ordinary. The relevant, I don't know whether one refers to Hansard in Man, but the relevant clause was introduced in the Legislative Council on the 25th of March 1997.
And to what extent should we regard that as relevant?
Well,
or admissible?
Well, Lady, first of all, without delaying the argument by delving into Pepper and Hart.
Why not?
My submission is that when when the court below takes a view of what the legislature could have done, it becomes relevant to look and see what in fact was said at the time. And that's why we rely on the manner in which it was introduced by the former First Deemster in March 1997. He'd become a legislator, a member of the Legislative Council, and it's in our case.
We've read what you say in your case.
Yes,
Nevertheless, the admissibility is governed by principles in Pepper and Hart, as further explained in Spath Home. And as I understand it, it's when a minister has made an unequivocal statement to Parliament as to what the meaning of a particular provision is, and then seeks to argue for a different meaning in litigation in which the government is itself involved, then it may be admissible, but otherwise not.
Well, Milady, I don't know whether, I don't know enough about the Manx Constitution to know quite how one should treat the former First Deemster when he introduced this legislation in Tinvald.
Yes, but he's not a party to this litigation.
Well, no, Milady, but when, as I say, the staff of government division, if I can use a colloquialism, lead with their chin as to what Tinvald might have done, then my submission is quite simply that it is relevant to look and see what Tinvald in fact did do and how the clause was introduced.
But I'm not sure that quite captures the essence of what they're saying, because they're saying there is a legislative device which could have achieved very easily the objective which the appellant argues for. That was not availed of by Tinvald, and therefore the proper construction to place on the disputed provision is the plain and the obvious meaning of the provision. So recourse to what is said in Tinvald isn't necessarily going to answer that conundrum,
Well,
if indeed there is a conundrum.
the question of whether there is a conundrum and how long we need to detain ourselves to the answer to it is perhaps by the way. But
Well, we would be failing in our duty if we had not drawn this problem to your attention.
Oh, I could see it coming. I can assure you. But I'll just summarise, I hope in no more than a couple of sentences, what I'm saying on this point. And it is simply this. Paragraph 61, the Staff of Government Division speculate about what Tinvald intended. And it's for that object, to examine what Tinvald appears to have intended, that I draw attention to what was said by someone who obviously had, as a former First Deemster, a great understanding of the law of limitation and Manx law.
What is between you and the respondent on this point?
Well, I'm not sure that Ms. Michelos's concession goes as far as accepting that this is wrong, but she'll correct me if I misunderstood her position. It is this, that it's not an issue that needs to detain us very long, because both need to be looked at. I think that's a fair summary. So, turning now to the exercise of the discretion, I think the committee now has my submission fairly clearly, but let me see if I can draw it together. The exercise of the Deemster's discretion, we say, was indeed invalidated by the combination of his error of law and his consequential focus, which one can see from looking at the judgment as a whole, on a small part of the overall delay of 4 years. Now, you will have seen from reading the Staff of Government Division's judgment that they differed from Deemster Corlett and confessed at paragraph 58, page 85 in the bundle, that they were bound to say that on the evidence each member of the court would have declined to disapply the limitation period. But they then proceeded to dismiss the appeal on the basis that they could find no error of law in the manner in which the Deemster had exercised his discretion. Well, that, of course, is an approach which can hardly stand in the light of the concession made by Ms. Michelos. And my submission is that their inability in the Staff of Government Division to find such an error of law was quite simply because they fell into the same error themselves, and therefore it wasn't open to them to treat Deemster Corlett's decision as within the range of reasonably possible conclusions open to him. Those last words I quote from the final part of paragraph 58 of the Staff of Government Division judgment. And it's that approach that is really the sheet anchor of Ms. Michelos's submissions. That brings me to the second ground of appeal. This ground of appeal raises the question whether, when considering for the purpose of section 30A 2B Roman 2, the claimant acted promptly and reasonably after discovering the cause of action, it is permissible for the court to infer that he did so, even though he had chosen to give no evidence to that effect. Promptly and reasonably are the adverbs to be found in 30A 2B2. It is an explicit matter to which the court is asked to have particular regard. Those are the introductory words of section 30A, subsection 2. Now, it's elementary that the burden of proof is, of course, upon the party seeking to disapply the limitation period. That was made clear by Lady Hale in Steedman and the BBC, which I would ask you to look at in bundle 7 at page 1525. Bundle 7, 1525. The burden on the claimant is set out in the first sentence of paragraph 33 of Her Ladyship's judgment. And then if one goes to look at Lord Justice Brooke, that phrase that I used, time is of the essence, is to be found in paragraph 37 of his judgment. And I'd ask you to look at that and then just read on to his citation of part of a judgment of Lord Justice Glidewell in Grovitt and Doctor, which is at the top of the next page. So that we don't have to come back to this decision before we leave it, could I just ask you to flick back to the judgment of Mr. Justice David Steele in paragraph 15, which is expressed in terms which, again, I suggest doesn't permit a distinction to be made between availability and cogency. A second point before we leave this case is to be found in Mr. Justice David Steele's judgment at paragraph 25, where he deals with the relevance of the existence of a claim against the solicitors for the party concerned. Paragraph 25, in the last two sentences, he says, "The fact remains that the existence of the claim against the solicitors ameliorates to some extent such prejudice as flows from the impact of the limitation period. The extent of that prejudice, in turn, depends upon the strength or otherwise of the claim." Now, we know so little about what happened here in the relevant 5.5-month period that one can't say for sure that there was a claim by Mr. Willers against his legal advisors, but it's certainly a very strong possibility. And finally, I should have perhaps referred to this a moment ago, in the judgments in Steedman, the paragraph 45 in Lord Justice Brooke's judgment, which we say needs to be applied here. Paragraph 45, page 1528. If claimants places little information before the court when inviting a section 32A discretion to be exercised in their favour, as occurred in the present case, they should not be surprised if the court is unwilling to find that it is equitable to grant them their request. And my submission is that that makes the absence of evidence on this point from Mr. Willers, and also from his Manx advocate, Mr. Wannenberg, W-A-N-N-E-N-B-E-U-R-G-H, especially significant, because the Deemster, as he himself acknowledged at paragraph 35, was left to speculate, the Deemster's words, about what had occurred during that 5.5-month period. He was right in our submission to say he was left to speculate, and it follows from that that he was not, as he says, entitled is a strong word in the circumstances, entitled to assume that detailed legal advice had been given and research undertaken in a specialized area of law. Entitlement is the word he uses in paragraph 39 and repeats in paragraph 41. So can I just...
Well, could I just
Yes.
interject one moment? In the third line of 39, did the Deemster mean by the expression to assume, to infer? Would that have been expressing more accurately what he was trying to do?
Well, I wouldn't accept that it was a legitimate inference, and it's really the use of the phrase entitlement that I take issue with.
I see.
And as I say, he uses that twice in circumstances in which he is forced to speculate his own words because of the paucity of evidence. And can I just remind the committee of the exiguous evidence before the Deemster? The relevant date of the acquisition of knowledge is the 22nd of June 2013. Mr. Willers says that as soon as he was aware of the letter, he instructed his Manx lawyer, Mr. Wannenberg. And perhaps we ought just to see how slim is the evidence on that, and we can do that by looking at Mr. Willers' first witness statement of the 29th of January 2016, which is at Bundle 2, page 297. This stage in the witness statement, the paragraphs cease to be numbered, but it's the beginning of the second paragraph, page 297. As soon as I was aware of the letter, I instructed Mr. Wannenberg. Following consideration, the claim was issued. But we're not told there what instructions were given to Mr. Wannenberg. Very significant omission. A week later, a week after the acquisition of knowledge, on the 29th of June 2013, Mr. Willers, having instructed Mr. Wannenberg, seeks the opinion of his English solicitor, Mr. de Cruz. And one can see what the evidence is in relation to that if you go to page 555 in Bundle 2, the witness statement of Mr. de Cruz of the 24th of February 2016. And I don't think I need to ask you to look at more than the final paragraph, paragraph 7. On the 29th of June 2013, Mr. Willers emailed me a copy of the 7th of October 2009 letter from the defendants to the Isle of Man Customs and Excise and asked me for my opinion on it. I suggested, says Mr. de Cruz, that he obtained specialist counsel's opinion just to be sure before considering proceedings. Well, the rest is silence. We simply do not know what happened next, whether the advice to obtain specialist counsel's opinion was taken, or indeed what was going on during the period of getting on for 6 months before proceedings were issued. The approach of the staff of government, as one can see at paragraph 54, at page 84, was to say that the Deemster was entitled, once again we see the language of entitlement, was entitled to exercise his discretion so as to conclude that Mr. Willers had acted promptly and reasonably once he'd discovered the existence of the letter. Well, my submission is that there was no entitlement given the paucity of the evidence, and it wasn't right to talk about the exercise of discretion. There is perhaps potential there for an evaluative judgment based on facts.
If they had said it was open to him, would you have any quarrel with that?
Yes, I would, and I'll explain why. Because
yes.
the evidence is simply lacking, which would have justified such an inference. And indeed, the silence tends to reinforce our position that the delay was not reasonable or prompt, but inexcusable. The lack of explanation, we say, fortifies our submission. I'll come on to that. It's based on the approach of the Court of Appeal in a case called Wisniewski, and also what Lord Sumption said in Prest. So the use of the word discretion is, we say, more than a mere linguistic quibble. The basis of the inference, if it can be made out at all, is the documentary evidence in the case, not an assessment of oral evidence of witnesses. And consequently, this committee is in as good a position to make an assessment as the court or courts below.
Well, there's been some recent jurisprudence about this, hasn't there? In the case of McGrady and McGrady.
Yes, there is another case which I was looking at over the weekend. There's a passage in the judgment of Lord Reed.
There's also discussion in the case of DB against the Chief Constable of the Police Service of Northern Ireland, which discusses the very point that you're now making, namely whether a distinction of significance should be drawn between the assessment by a first instance judge of oral testimony and inferences that he draws from documentary material.
Well, my submission is that if it is a true discretion, then there is the generosity given to what a judge in the circumstances could reasonably have decided. If it is an evaluative finding, then the appellate court can look at it and take a view much more easily and with much less hesitation than in relation to the exercise of a discretion. And that's why I say this is more than a mere linguistic quibble, because my submission is that the error of referring in paragraph 54 of the Staff of Government Division judgment to an entitlement to the exercise of discretion recurs in Miss Michalos's case. what the Deemster was purporting to do was to draw an inference of fact. Now, the court below, the Staff of Government Division, criticised at paragraph 54, and rightly we say criticised as unfortunate being their word, the use by the Deemster of the words speculate and assume. But speculating was precisely, we contend, what the Deemster had done. And the Staff of Government Division were wrong in saying, in effect, that his conclusion would have been permissible if he dressed it up as a reasonable inference. The reason for that, again, is not a linguistic quibble. It is quite simply that it would not have been a reasonable inference for the reasons that we set out in paragraphs 24 and 25 of our case.
You were submitting that this court, or the appeal court in the Isle of Man, would have been in as good a position to take a view. You may not have gone quite that far, but that was the direction you were going,
yes,
if this was an inference being drawn from material. In this particular case, the Deemster had his own personal knowledge of other litigation that was going on. He'd already used it to suggest that there might be an adjournment, for example. This court and the Court of Appeal in the Isle of Man didn't have that.
Well,
What do we make of that?
Well, there is, of course, a background of ill feeling between Mr. Willers and Mr. Goubet. A background of ill feeling.
I think ill feeling is putting it mildly. And background, when one considers the amount of litigation that there is.
Yes, and that's...
Which has arisen out of that.
Indeed, and of course your ladyship was party to the decision of the Supreme Court in the prosecution case.
I was indeed.
But it becomes all the more important then to keep this, which on the face of it is a relatively simple issue based on the limited publication of a letter to the Customs and Excise making a discrete allegation of VAT defalcation within reasonable bounds, and not to allow the case to be extended by allegations of malice. We say ill-founded allegations of malice. It's a simple matter, and in my respectful submission, particularly at the stage at which it was being dealt with by the Deemster and the Staff of Government, they should have sought to confine the issues and not allow them to become, if you like, a rerun of the issues which have had to be canvassed in the trial of the malicious prosecution litigation, which I gather has just concluded after 19 days in front of Lady Justice Rose. It was a colossal piece of litigation with, I think, am I right in thinking 63 lever arch files for her ladyship to have to deal with. So,
Is it Her Ladyship's last case in the Chancery Division?
yes, it is. I hope her step out will not be delayed by having to produce the judgment. So, just stepping back from answering Lady Black's question, what we say is this, that the truth is that if the advice of specialist counsel had been sought, and we're not told whether it was or it wasn't, he or she would have seen immediately that fundamentally this was a simple issue, whether the letter was defamatory, and if so, the precise, natural and ordinary meaning. Wouldn't take very long to work out whether the letter was defamatory, but counsel would have doubtless seen that given that it was addressed to the Customs and Excise, it was the subject of qualified privilege. And all of that could have been done, we could have been told all about what did happen in that period without having to waive privilege in the advice actually given. The argument that Ms. Mikalos advances in paragraph 35 of her case is, we say, misconceived. The suggestion of a spectre is alarmist and wrong. If specialist advice had been sought, that fact could have been stated without waiving legal professional privilege in the actual advice provided. But I repeat, the critical point is that it is never said that specialist counsel was consulted, and hence speculation about the effect, if he or she had been consulted, of the long vacation is really that. It comes precariously close to giving evidence. And of course, the range of possible consequences, possible explanations for the delay is considerable. I don't want to have to ask you to wade again through what we say in paragraph 24 and 25 of our case. But one example that occurs to me is that if specialist English counsel had been consulted, then, as I've said, it was obviously manifest that the publication was the subject of qualified privilege, and they may have felt at that stage that there was no or insufficient evidence of malice. And we'll see precisely how the case on malice emerges. And in relation to the point in paragraph 25.3 of our case, the claimant's Manx solicitor's letter of the 30th of October 2014 shows that they believed that the limitation period didn't start to run until the date of knowledge. Can I just ask you to look at that letter? It's in bundle 5 at page 1109. This, as it happens, is a letter which seems to have been signed off by Mr. Wannenborough. You'll see on 1108 that at the top of the page it says reply Walter Wannenborough, and at the bottom of 1109 is the heresy that the limitation period didn't start to run until the date of knowledge. Now, my point on that is quite...
mixing up personal injury claims with defamation claims.
Yes, I imagine so, but the point that I make is a slightly different one, and it is that such a fundamentally erroneous belief is hardly consistent with having taken the advice of specialist counsel the previous year. Any specialist in the field would have immediately flagged up the point that the course of action was statute barred and that immediate action must be taken to deal with that. And just to complete this part of my submission with a repetition of a point I've made already based on Steedman, the fact is that if advice was taken and it was erroneous, then a claim would lie against the advocate or specialist advisor who had given it. And as we saw, looking at Mr. Justice David Steele's judgment in Steedman, he cites Lord Diplock in Thompson and Brown, who uses the words, the fact that he will have a claim over against his solicitor must be a highly relevant consideration. So what we say Deemster Corlett did was impermissibly to plug the evidential gap, and the Staff of Government Division erred in treating that error so forgivingly. Far from being entitled to make assumptions, we say, the Deemster should have inferred from the claimant's failure to produce any evidence that there was no good reason for the delay, all the more so given the burden of proof placed upon him. And the basis of that approach is derived from the well-known case of Harrington and the British Railways Board, and Wisniewski and the Central Manchester Health Authority, a decision of the Court of Appeal in 1998. And perhaps I can ask the committee to go to that, because there is a helpful summary of the correct approach in cases where silence is relied on as probative by the opposing party by Lord Justice Brooke. So that's Bundle 7. Starts at page 1540. It was a medical negligence case originally tried by the future Lord Thomas. And if the committee goes to 1552, the basis of the approach is described in a passage from Lord Lowry at the foot of 1552, which recurs as a citation in Lord Sumption's judgment in Preston Prest. And then at the top of 1553 are the four principles of the approach. So perhaps if I can just ask the committee to read from the beginning of the quote from Coombs to the end of the fourth numbered paragraph on 1553. So the point in a nutshell is that the silence of one party in the face of the other party's evidence may convert that evidence into proof in relation to matters which are or are likely to be within the knowledge of the silent party, and about which that party could be expected to give evidence. We legitimately have expected Mr. Willers and Mr. Wanborough to give proper evidence, and they failed to do so. And then, while you have Bundle 7, I'm not sure anyone's looking at the hard copy, but at any rate, while I'm in Bundle 7, at page 1473 is the most recent reference to Wisniewski that we've been able to find in the judgment of Lord Sumption in the Prest case. So page 1473, Lord Sumption cites Lord Diplock in Harrington, and then says that the courts have tended to recoil from some of the fiercer parts of Lord Diplock's statement. And then these words, which I rely on: there must be a reasonable basis for some hypothesis in the evidence or the inherent probabilities before a court can use useful inferences. Can draw useful inferences from a party's failure to rebut it. And then he cites Lord Lowry in T.C. Coombs and compares that with Wisniewski. So we say this is a case where the silence cries volumes. Now, although Deemster Corlett cited the Court of Appeal decision in Bury and Reed Elsevier, we say he failed to apply it in the respects in which we've listed in our case at paragraph 26. Bury and Reed Elsevier is in bundle 6 at page 1264. Can I ask you just to go to that very quickly to see what is said there by Lady Justice Sharp? In a nutshell, as one can see from paragraph 5, at page 1267, she is saying that special considerations apply to libel actions, and the reason for that is not least because the purpose of a libel action is the vindication of the claimant's reputation, the public vindication, I think I can legitimately say. And therefore such actions ought to be pursued with vigour, and where the claimant does not, her words not mine, get on with it, and there is unexplained or inadequately explained delay, it's not surprising if the court is not convinced that it should lift the limitation period. And there at paragraph 8, she is echoing what was said by Lord Justice Brooke in Steedman in a passage which I've already referred you to. That brings me to the disposal of the appeal. Our submission is that the board can and should exercise the discretion afresh for both the two reasons on which I've been concentrating, and having done so, dismiss the action as statute barred. Having regard to what we can see of the facts, by no stretch of the imagination can this be described, as Ms. Michaelos does, as, quotes, an error of the most technical kind. It was fundamental for the reason that I've given. There was a focus on far too short a period of the overall delay. In re-exercising the discretion, the starting point must surely be that on the evidence before the Staff of Government Division, both of their honours would personally have disallowed the application. That, for your note, is paragraph 58. One assumes that what they had in mind in expressing that view was in particular the material to be found in Mr. Nugent's second witness statement of the 16th of February 2016, which you have in the bundles at bundle 2, page 353 to 361. Now, I know I'm not overrunning time. So
Nowhere near.
I'm not
But
nowhere
don't let's encourage you.
No, I know. I wasn't encouraged. I was simply going to try and build on that to say that I would ask the committee to read this document in its entirety, because it really draws together what we say about the basis of the Deemster's decision and also that of the Staff of Government. And the contents of it are highly relevant to the exercise of the discretion afresh. I've tried to break down my submissions on this issue into two. Firstly, the prejudice to Mr. Nugent and BDO in having to meet a claim with serious allegations of malice and dishonesty so long after the event. And secondly, the lack of prejudice we submit to Mr. Willers if he can't pursue the action, not least because of the inherent weakness of his case. So, first part, the prejudice to Mr. Nugent and BDO in having to meet the claim so long after the event. I have 5 points. Firstly, being sued for defamation is in itself a serious interference with freedom of expression, as one sees from the case of Brady, and I think from something also said by Mr. Justice Tugendhat. The quote is in Bundle 6, page 1282. And Brady is a case heard by a court presided over by Sir Anthony May, then the president of the Queen's Bench Division, and it's to his judgment that I go. Paragraph 19 of 1282, one sees that following on from Mr. Justice Tugendhat in a case called Lonzim and Sprague, the fact of being sued for slander is itself a serious interference with freedom of expression. And that's partly why libel actions raise different considerations to personal injury actions, and as it happens, the staff of Government Division acknowledged that point at paragraph 37.
I'm sorry, whereabouts?
Yes, my lady. Paragraph 19,
19,
about 8 lines down. Mr. Justice Eady referred to a passage in the judgment of Mr. Justice Tugendhat in Lonzim and Sprague. That the fact of being sued for slander, same goes obviously for libel, is itself a serious interference with freedom of expression. That would be a factor relevant to prejudice, which would have no application in personal injury proceedings. In other words, an echo of the distinction that your ladyship was seeking to make a moment ago. Before we leave Brady, can I also just ask you to look at paragraph 21 in Sir Anthony's judgment, where again he refers to how considerations in defamation claims are likely to be different. The policy behind the much shorter limitation period is clear. The defamatory impact of libel or slander is likely to be transient, and Parliament evidently intended that a claimant should assert and pursue his need for vindication speedily. So can I just say something as my second point under this head about the introduction of the plea of malice? Malice was not originally pleaded in Mr. Willers' reply to the defence of the 10th of February 2014 raising qualified privilege. The defence can be seen in Bundle 1 at page 107. And I needn't go through paragraphs 17 to 24, but there it is, pleaded fairly and squarely as a defence. One can see the strength of that as an argument of law. Obviously, the Customs and Excise were the right people to whom to make a complaint if a complaint was justified in the circumstances. It's the relationship between the publisher and the publishee that gives rise to the occasion of qualified privilege. Now, any practitioner acting for a claimant who sees a defence of qualified privilege raised obviously immediately starts to think, well, can I meet that by a plea of malice which would destroy the prima facie defence of privilege? Which makes the fact that the reply dated the 30th of June 2014 was signed by Mr. Wannenborough as the advocate without raising malice. The reply in its unamended form is it starts at 115, and the signature of Mr. Wannenborough as advocate for the claimant is at 118. Now, Mr. Wannenborough must surely have considered and then rejected whether there was a proper case of malice to raise in answer to the plea of qualified privilege. Now, Mr. Goubet, as the committee knows, died on the 5th of January 2016. Only after his death, on the 25th of February 2016, did Mr. Willers in person settle an extensive amendment to the reply alleging malice for the first time. Mr. Goubet was barely cold in his grave. And one sees that extensive document at page 120, I think. Just forgive me while I check that. Yes, it's 120, and it runs on to 130. In a nutshell, what was alleged was a conspiracy, alleged for the first time, which is so significant, after Mr. Goubet was dead, that my client, Mr. Nugent, and I'm looking at paragraph 5, halfway down page 121, had conspired with Mr. Goubet to assist Mr. Goubet in his vendetta against the claimant in any way which he could, part of which was the contrived VAT allegations, that those being the allegations contained in the letter in 2009. And you'll see how, over and over again, but without particulars, but with great emphasis, it's said by Mr. Willers that Mr. Nugent had conspired with Mr. Goubet. To take as an example, paragraph 12 on page 113, in 2009, the first defendant deliberately and maliciously had Mr. Goubet instruct him to generate a significant money claim against the claimant for allegedly underpaid VAT. A curious allegation, but there it is. This was contrived, he said. May want to be fair to Mr. Willers, read the whole of paragraph 12. He says that vendetta culminated in the 2nd of October 2009 letter, and it can't be said that the language is understated. The end of paragraph 13, it's said to have been malicious and vindictive to further advance the vendetta which Mr. Nugent was assisting Mr. Goubet to pursue against Mr. Willers. There's another respect in which Mr. Goubet is brought into the frame, and that's in paragraph 26 on page 124, where it is said that the personal expenditure reimbursed by CAV to Mr. Willers was, this is the fourth line of paragraph 26, at the direction and express agreement of Mr. Goubet. So it's late in the day, February last year, that all of this is introduced, and introduced when Mr. Goubet could not assist Mr. Nugent in answering it. And that's really my third point, that there is a serious prejudice to the appellants in not having the evidence of Mr. Goubet. Fourth point relates to the scale of the issues raised by Mr. Willers in the amended reply. Here, perhaps I can just ask you to go to Mr. Nugent's second witness statement dealing with all of this. It's in bundle 2 at page, the relevant bit for my present purposes is at page 355. Paragraph 18, my lady. Mr. Nugent starts by making the point that the allegations made now in the reply by Mr. Willers were not something which his advocate chose to challenge on a previous occasion. And he goes on, if this is now to become an issue in these proceedings, as it appears Mr. Willers intends for it to be, that is a matter which will require very significant disclosure and witness evidence going back over 20 years. And that's surely right, unless Gordian sword was to be taken under the guise of case management to the plea of malice advanced by Mr. Willers. Paragraph 21, Mr. Nugent says that it's about 10 lines down, paragraph 21 on page 356. If the court is to determine the allegation which Mr. Willers now makes in these proceedings, then that those witness statements contain voluminous false statements, then that will clearly involve detailed examination of a very large amount of documentary material and evidence from several witnesses. One of the consequences of the fact that these proceedings are not brought within the limitation period is, of course, that Mr. Goubet will no longer be able to assist the court in giving evidence on the serious allegations which are made against him, and so on. And then in paragraph 28 is a development of the point about the failure to challenge Mr. Nugent on a previous occasion if it was really being said that he had forged a note of a meeting on the 21st of July 2009. Paragraph 29, that there is, to use Ms. Michalos's term, the spectre, and more than a spectre perhaps, that there will need to be expert forensic examination because of the extent of the allegations of fabrication and forgery of documents. That brings me to my fifth point on prejudice to Mr. Nugent if Mr. Willers is allowed to proceed, and it relates to stress. Mr. Nugent at paragraph 48 deals with that. And it deserves, as I say, to be read at length, this statement. In particular, in the light of what he says in paragraphs 4 to 16. Because what Mr. Willers decided to do was to suggest that the allegedly malicious and vindictive conduct of Mr. Nugent was because, and the reason he did, to put it the way Mr. Willers does, the reason he did the bidding of Mr. Goubet was in the hope of receiving £1 million legacy on Mr. Goubet's death. All of that is set out in paragraphs 4 to 16, and he has to deal, as he says in paragraph 48, with highly private and personal issues and outrageous allegations in the light of what was being alleged by Mr. Willers. And it's notable that in the month before Mr. Goubet died, leaving half of his estate to a charitable foundation, which has been set up and of which Mr. Nugent is the leading trustee, you can see all about it. I'll just give the reference. If you go to Bundle 2, page 551, the foundation has already, I'm told, made a number of significant £1 million donations to charities. It's significant that in the month before Mr. Goubet died, Mr. Nugent had to persuade the dying man not to leave him £1 million legacy, which is an indication of the integrity of my client, in contrast to the fact that the same month, December 2015, Mr. Willers was trying to get Mr. Goubet back for further cross-examination, notwithstanding the evidence of the jointly instructed medical expert that Mr. Goubet was a dying man. Now, I'll take this quickly, but there is a short judgment of Deemster Corlett of the 23rd of December 2015, just a few days before Mr. Goubet's death on the 5th of January, in which he deals with this issue of the evidence of Mr. Goubet. Could we... Just to give you the chronology, to the background to this, on the 3rd of April 2014, Mr. Goubet had been cross-examined in proceedings in the Isle of Man, but was unable to go on. On the 25th of March, so just under a year later of 2015, he was admitted as an emergency to hospital in Chile. And on the 7th of April 2015, an application was made that he should be excused from further attendance for cross-examination. That, I think, is all you need to know. But if you go to the last page of the 5, paragraph 40, Deemster Corlett says, I don't accept that Mr. Goubet has, as is alleged by Mr. Willers, made every effort to avoid coming back to court. I accept entirely that frailty by itself does not suffice. Mr. Goubet is 87 years old, and then he gets on about old age, but it's clear that he doesn't accept what is being alleged by Mr. Willers. And then in paragraph 41, and important for the purposes of assessing prejudice in these proceedings, the Deemster says, this is a case where, as I said in my judgment of the 15th of September 2014, particularly at paragraph 53, the credibility of the key witnesses, Mr. Goubet and Mr. Willers, is central to a proper determination of the conflicting evidence. And then, having considered the evidence of the jointly instructed medical expert on Mr. Goubet's state of health, you'll see 44, Dr. Turkington is that expert, it would be tantamount to inhuman or degrading treatment and cannot be countenanced. It's likely to be undignified in a scenario which I believe no right-thinking member of the public would wish to support witness. Paragraph 46, putting it bluntly, if I do not grant this application, I will be faced with the cross-examination of a person, in essence, on their deathbed. So when Mr. Goubet is on his deathbed, he has Mr. Nugent saying, please, please, please do not leave me £1 million, and Mr. Willers insisting that he come back into court. That brings me to the other side of the coin, the lack of prejudice to Mr. Willers if he cannot pursue the action, we say not least because of the weakness of his case. Firstly, 4 points here. Firstly, Mr. Willers' witness statement of the 29th of January 2016. It's a 19-page single-spaced document at Bundle 2, page 280. That witness statement, lengthy though it is remarkable for what it does not say. There is not a single word in all those single-spaced pages about how or why Mr. Willers would be prejudiced if he was held to the limitation period. Secondly, on damage to reputation, the letter to Customs and Excise of the 7th of October, not sure that I've given you the reference, we do perhaps need to refer to it, but the reference is in Bundle 1, page 215. The letter to the Customs and Excise does not seem to have caused any personal or professional damage to Mr. Willers. Even 9 years down the line, there is still no evidence of any actual damage to his personal or professional reputation, such as would give rise to a substantial award of damages. Looks like one of those cases where it's said that the game isn't worth the candle. And there is no justification with respect to the Deemster for his comment at paragraph 53 that such evidence may yet emerge. That, with due respect, was fanciful. The fact that Mr. Willers didn't find out about the letter for nearly 4 years and only got it as a result of a subject access request is in itself, we say, an indication that it didn't cause, still less was continuing to cause any damage. My third point relates to the lack of need for public vindication. That's in the main because of the limited circulation of the letter, and I rely on that passage in Sir Anthony May's judgment in Brady and Norman that we were looking at just a moment ago. Finally, point 4, an injunction. There is no need for what is normally a most important part of the relief sought in a libel action, namely an injunction against repetition. Indeed, as one can see if one goes to the prayer to the particulars of claim at Bundle 1, page 103, there is no claim for an injunction, just a claim in the prayer for damages and costs. It's perhaps not surprising that there is no claim for an injunction because Mr. Nugent and BDO had provided an undertaking not to repeat as long ago as the 15th of November 2013 in a letter that you'll find at Bundle 1, page 265. Sorry, I think I've given you the wrong reference. 274, I'm sorry, I've read the wrong page number. 274, milady, 15th of November 2013, the third paragraph of that letter at 274. So to conclude, if, as the appellants contend, the discretion to extend time should not be exercised in the respondent claimant's favour, the defence of limitation is bound to succeed and the action should now be dismissed. I think, find anything in Ms. Michelos's case in which she suggests that it would not be right for this committee to re-exercise the discretion vitiated by the amendments to which I've referred in the course below. Those are my submissions. Thank you very much.
Thank you, Mr. Brown. Mr. Dean? Ms. Michelos.
The respondent submits there's only one issue in this case, and that's whether the judge below exceeded the generous ambit within which reasonable disagreement is possible in the exercise of the discretion. The appellants have attempted to create a dispute of law when in fact there wasn't one. Mr. Brown in his submissions repeatedly said the ground of law is conceded. The case of the respondent actually says it's not disputed, and it was never disputed. It was never disputed in the notice of objection to this committee. And in fact, the whole of the appellant's case is based on a mischaracterization of the judgment of both Deemster Corlett below and the staff of government. I'd ask the committee to go back, please, to the judgment of Deemster Corlett, which is in the first bundle, paragraph 32, page 58. The committee has already looked at this, but I would submit it bears looking at again because it exposes the gross mischaracterization that infects the appellant's case. The section is headed delay. Firstly, there is the issue of delay. There are, in my view, two aspects to the issue of delay. Overall delay. The first is the overall delay in this case. And the Deemster there is specifically saying the cause of action arose in October 2009, and it's now March 2016. And he goes on to say the fourth sentence there, the relevant period of delay, in my judgment, which my Lady Black picked up on with Mr. Brown, is between that time and the date on which proceedings were issued. It's submitted that this is absolutely clear that the Deemster had in mind the overall delay, but was choosing to, in his judgment, focus on a particular period. It's said against the respondent that the respondent's case confuses relevance and weight.
Is he focusing on the particular period of delay for the particular purpose of Section 30A2B2? Or is he focusing on that particular period of delay generally?
I think I would submit he's focusing it on the purpose of that section. And if we go back to the previous page, PC 57, the top of that page, he's referred to Steedman and the BBC, and the bottom of the quote, paragraph 1, refers there specifically the reasons for the delay and the extent to which the passage of time since the expiry of the limitation period had an impact on the availability or cogency of relevant evidence. And he's properly directed himself as well. So there are two aspects to this. One, all the relevant law is here. It's gone through carefully in this judgment. And then in the passage concerning delay, the overall delay is referred to. And then the bottom, to go back to page 58, at the bottom of that page, delay after date of knowledge, goes on to analyse that further. And then to turn...
The period of delay, other than that, occurring between the 22nd of June 2013 and the 5th of December 2013, is relevant, is it not?
He's saying it is relevant, yeah.
No, well, is he saying that? Why does he isolate that period as the relevant period when, as I think you accept, the earlier period is also relevant?
Because in a case, this, prior to June 2013, the respondent didn't know about the existence of the letter. So in any case where there's a date of knowledge issue, particularly this is a defamation case, don't forget. So it's not a case where, for example, in a personal injury case, one might have constructive knowledge. This doesn't apply. This is a situation where someone does not know about it at all. And that is something that is relevant. In fact, while we're on this point, if the committee could look at Bury, which is in volume 6, page 1274. This is the judgment of Lady Justice Sharp, paragraph 37. Middle of their C, there's a material difference, it seems to me, between not knowing you have a claim at all, so you're not in a position to bring it, let alone progress it, and knowing you have a claim but not progressing it so it becomes time barred. And it's submitted that that's particularly acute in this case because it is a pure date of knowledge case. There isn't any constructive knowledge at all. And so in those circumstances, there is a material difference, and a judge considering delay and the overall circumstances of the case is perfectly entitled to consider that a relevant period, a period that carries more weight in the assessment on any given facts, is more relevant. It is accepted that delay in this section encompasses all the delay, so it's delay post the date of limitation period as well, and that even if that weren't the case, the introductory words to the section make absolutely clear that all the circumstances of the case have to be taken into account, and it's a very flexible discretion. One of the reasons for the flexibility of that discretion is the fact that there's a one-year limitation period. And so, to go back to the point about the mischaracterisation, if the committee turns to the judgment of the staff of government, paragraph 33, which is volume 1, page 88, page 81.
I'm so sorry, can you give me that page number?
Page PC 81 in volume 1.
Thank you.
Paragraph 33 of the judgment of the staff of government. The line at the top there, we're satisfied that when considering the paragraph as a whole, it's not a fair interpretation of what he said. And at the bottom of that paragraph, moreover, Deems to call it did not say the only delay that failed to be considered was that between Mr. Willard's discovery of the letter and the issue of proceedings. And it's submitted that that is precisely the error that the appellants have fallen into in their mischaracterisation of the judgment. They're trying to read in to what Deems to call it said only relevant delay, and that was the only thing he considered when that wasn't the case at all. And that that this is really grasping at semantic straws as a ground on which to suggest that this decision should be overturned. And it's submitted that even if that analysis is correct, that on the facts of this case, the judgment and the way it was analysed and the direction of law, that this case sits squarely with the position adopted in the authority Cairn-Jones and Christie Tyler, where a similar argument was described as a technical failure. And I'd ask the committee to look at Cairn-Jones, which is in volume 6. It starts at 1284. And this is very similar, but in reverse, so that the judge below refused to extend the limitation period in a personal injury case. This case concerned hand-arm vibration syndrome as a result of using equipment, staple guns for an upholstery business. And there were issues of constructive knowledge and actual knowledge. The passages from this case that I would rely on are firstly paragraph 8, little 8, which is at the top of 1289. Just while we're in this authority. This is the principle which the committee is familiar with, obviously, that an appellate court shouldn't intervene unless the judge is so plainly wrong, either because he misapplied relevant principles or reaches a decision that's unsustainable. And that's equally applicable here, obviously, because it's the same kind of discretion. It's a very similar section, it's very similarly worded. It also takes into account all the circumstances of the case, and it is an unfettered discretion. And then we can see...
This is Lord Justice Elias, is it?
Yes. The bottom of paragraph 10 is the criticism of that's made on appeal. That's what's missing from the judge's analysis is consideration of the delay from the period when the limitation period expired. And we can see at the top of that paragraph what the judge did do, which he recorded the date from constructive knowledge and so forth. Then paragraph 19, page 1291. Principal ground of appeal of which permission was given. It's a failure to take into account the period from expiry. And then paragraph 29 is the conclusion. The middle of this is page 1293. In the middle, that was no doubt an oversight or infelicity in the structure of the judgment. It was an error, but of the most technical kind. And I would submit that is exactly the same as the case here. That if it is the case, which is not accepted, that the Deemster erred in failing to consider delay since the expiry of the limitation period at all, which does not appear to be the case from the judgment, and is a mischaracterisation. If that is wrong, then this committee should conclude that it was, in fact, a very technical error on the facts of this case, because it concerned date of knowledge and publication of which the respondent was completely unaware.
Well, surely what Lord Justice Elias is saying is that the structure of the judgment constitutes a technical error. He's not suggesting, is he, that leaving out of account other relevant periods of delay would be a technical error?
My submission is that the analysis in Cairns-Jones is the same as the case here. That,
Yes.
that it was, at best, it was a wording issue. It's a semantic issue about whether something was referred to specifically or not. And that the position here is the same. That it is both of the grounds of appeal in this case. I submit are linguistic quibbles, both of them.
Well, it's not a quibble to say, is it, that not considering a really quite, in the defamation context, and we're not here in the personal interest context, something approaching 4 years from the expiry of the primary limitation period, rather than 6 months after the date of knowledge, is just a linguistic quibble. I mean, everything depends, doesn't it, on whether, if one did take into account the earlier part of that 4-year period, I think it's 4 years from the date of publication, one would think there might be some prima facie prejudice to go into the scales. But I haven't found the judge expressly looking at that.
The point of it relates to the wording of the judgment, because the judge specifically does say, the paragraph we've looked at, that there is the overall delay, and he's considered it. What he's going on to say is that the relevant period, as in the part that carries the most weight when exercising this discretion, is the period from the date of knowledge to the date of issue.
But my Lord's point is that there is no discussion by the judge of the impact on the question of whether the delay is excusable or not, of the period other than the period from the date of knowledge.
Yes, but it doesn't, I'd submit it doesn't take it. It doesn't take the criticism of the judgment any further, because it's an unfettered discretion, and it is open to the first instance judge to accord more weight to different parts of the delay.
Right, but you accept that for the discretion to be properly exercised, the judge has to review, even though he may not articulate this in his judgment, he has to review the potential impact of all of the periods of delay.
It has to be, it is something that has to be considered, but I don't accept that in any given judgment there has to be a detailed analysis of every aspect of the period of delay, because it is open to the judge to conclude that certain parts are worthy of more attention than others.
I mean, is this a fair summary of the judgment? He, as you say in his paragraph 32 or whatever it is, he says, well, there is the delay from the issue of from the expiry of the limitation period, but then he then, as you say, goes on and looks at the relevant delay for the purpose of seeing whether the applicant acted promptly and reasonably. And obviously the relevant period, it only starts to run for that purpose, which occupies the central part of his judgment, from when he finds out about the letter. Then he comes back to evidence, credibility of consequences, evidence being unavailable, and it may be that, at any rate in relation to Mr. Goubet's unfortunate death, that's during the post-knowledge period anyway. And then at the end he comes back to look at prejudice overall. And my question is, can one really detect in his final return to the overall prejudice question whether he is taking on board the fact that the delay is really an awful lot longer than 6 months?
I think we can, because if we look at paragraph 63...
63?
Yes. It's
Do you have a page number?
Page 65.
Thank you. Yeah.
He specifically goes on to say there, I accept, this is the second sentence.
Yes.
And it's now over 6 years since the letter was published.
Yes.
And so I think that it is clear that he had that in mind. And that taken as a whole, the question for this court is whether that was a discretion, that he exercised discretion properly, acting within the reason allowed of disagreement, in which disagreement is possible, and it's submitted that he was. and it's in that way that I say that it's a linguistic quibble, because the ground of appeal is founded on nothing more than keeping hold of the way that the judge expressed himself, rather than a substantive judgment. If you look at the substantive judgment as a whole, all of the correct law is referred to. He's directed himself properly. He refers to the overall delay. He takes it into account. And he concludes that on these facts, a particular period is more relevant than another period. And but ultimately, it all boils down to the same thing, which is this is an exercise of discretion. And that the staff of government were right when they concluded they shouldn't interfere. And that the same position applies in this court, that even if the members of the committee individually take the view that had they been sitting at first instance and heard this, they'd have decided it differently, that's for a discretion appeal, it's irrelevant. And that the committee should adopt a cautious approach and should not interfere with an exercise of discretion below. Turning now to the construction issue as to whether the wording of the subsection C, the final words qualify unavailable as cogent. It may be helpful to actually look at the statute, which is in volume 8 at 1583. It's accepted there, this is 30A to subsection C. It's accepted that having regard to the delay means all of the delay, so post-limitation period as well as post-date of knowledge. And that in those circumstances, actually a debate about whether or not if the action had been brought within the period mentioned in section 4A becomes academic. However, insofar as there is, for those reasons, I think it's not actually necessary for the committee to make any determination on this. Primarily, as I've already said, this is a really discretion issue in the first place. But if it's considered it's necessary for the board to rule on this question, the respondent's submissions are in paragraph 23 of its case. And firstly, that the staff of government were right when they said that the words that if the action had been brought within the period mentioned in section 4A qualify only C2, and that's apparent from the way that the statute is presented and laid out, because if it's not, it doesn't appear. If you look for example at 30A, where the final section 30A1, where the final section is disjunctive from the subparagraphs. The natural and ordinary meaning of that is that it qualifies only cogency. That's unsurprising, because if an evidence is available or not available is a binary question, whereas cogency is a variable factor, and it makes sense for the court to be given some guidance as to the level of which it should be judging the cogency. But this doesn't lead to any absurd consequences, because when considering unavailability of evidence, the court still has the flexibility to judge cogency and unavailability within all of the delay. And it should be borne in mind as well that unavailability may also concern destruction of material and destruction of documents. And it may be the case that a defendant has deliberately destroyed documents during the currency of the limitation period. And that is a section that gives a great deal of flexibility to the court when considering any issues of either unavailability or cogency. As regards I think
the comparison had been intended to apply to both 1 and 2, one would have expected it to be differently worded. Relevant evidence is 1, less likely to be available, or 2, likely to be less cogent than if. 2 is the only one that is worded in comparative terms, less than.
Yes. It makes little sense if grammatically to be qualifying C1. But as I've already said, all of this is very, I submit, is academic, and it's particularly academic on these facts because the focus of unavailability relates to the death of Mr. Goubet, and Mr. Goubet died both after the date of knowledge and after the limitation period expired. So it isn't something that makes any difference in this case anyway. And so for those reasons, I'd say it isn't necessary for the court to make a decision on it.
Is it relevant that he also died after the proceedings had been issued?
I would submit that, yes, it is. And that also relates to the question of if it is the board is persuaded that it should exercise its discretion afresh, which I would submit is something it shouldn't be doing because there shouldn't be a basis to interfere with discretion in this case. That actually it is a factor because there was time had it been thought necessary to obtain evidence from Mr. Goubet.
But your point on the wording of C1 is that the unavailability may be due to actions taken during the Section 4A period. Is that what it comes to?
That's one aspect of it, but that unavailability covers a wide range of things, and if it's I suppose there are two points to it. One is unavailability, as I've said, is a binary factor. It's available or it's not available, or it is likely to become not available, whereas cogency is variable. And the second point is that unavailability would cover destruction of documents by a defendant during the primary limitation period, as well as things going missing and witnesses disappearing, going beyond the jurisdiction or dying. There isn't any practical need for the court to be given any guidance as to how it should be judging that standard in the way that it does with codes.
Except that it says the extent to which having regard to the delay, and the delay is not issuing in the primary limitation period, isn't it? So that doesn't really cover destruction of documents by the defendant during the primary limitation period.
Well, I think it would do, because it would be, if it had been issued, it goes back to the point that it's not open necessarily for a defendant to say, well, I could have issued on the very last day of the limitation period. That it might be the case that if documents were destroyed towards the end of the limitation period, that had the claim been issued in time, those documents would have been available. But I think, as I've said, all of this is very academic anyway, because the intro section says the court shall have regard to all the circumstances of the case.
Lord Oliver indicated that delay, including the primary limitation period, may be relevant.
Yes.
So,
Well, on that, I would go back to the passage we looked at from Bury and Reed Elsevier, which is that where you're looking at a date of knowledge case, it's likely that the period from the date of knowledge is going to be more relevant, because a claimant who doesn't know they have a case can't bring a case. So
one could imagine, could one not, that the conclusion might have been reached but hasn't. That delay has to be interpreted going back to where it first appears, where the reference is to delay on the part of the claimant. And one might then think that the only relevant delay is delay for which the claimant is responsible. Now, that isn't how the thing has been interpreted. Were that to be a live issue, which it isn't, that would indeed be the sort of point of law of general public importance with which this board is normally concerned. Would that be an appropriate moment at which to adjourn?